Hello students, today we are going to discuss lecture number 18 of CPC, in which we are going to deal with pecuniary jurisdiction of the courts under section 6 of the Code of Civil Procedure 1908. Pecuniary jurisdiction has been given in section number 6 of CPC. As per section 6 of the Code of Civil Procedure 1908, what is the bare language of section number 6? Save in so far as is otherwise expressly provided. What does it means? If anything otherwise expressly is provided in the Code of Civil Procedure 1908, then section number 6 will not apply to that code. But what is stated in section number 6? Nothing herein contained. Nothing herein contained means nothing in CPC shall operate to give any court jurisdiction over the suits, the amount or value of the subject matter of which exceeds the pecuniary limits, if any, of its ordinary jurisdiction. So, if the court is exercising its ordinary jurisdiction and there is pecuniary limit prescribed for that particular court, then that court cannot exercise its jurisdiction beyond its pecuniary limit. So, what is the meaning of pecuniary jurisdiction? Pecuniary jurisdiction means the value of the suit. So it relate with the value of the suit, what the value of the suit has been given in the plaint. The court cannot go beyond the pecuniary jurisdiction conferred upon it by the law. What are the various circumstances in which this section is attracted? It is very important. For invoking the provision of section number 6, for applying the provision of section number 6, there are two conditions which must exist in every case. The first condition is that there must be the pecuniary limit prescribed for a court, and number two, the court for which the pecuniary limit has been prescribed must have entertained the suit. Now let us discuss these conditions one by one. Number A, the pecuniary limit must have been prescribed for a court, because some courts have unlimited pecuniary jurisdiction. For example, High Court and District Court have the unlimited pecuniary jurisdiction. No pecuniary limit has been prescribed for the High Court and District Court. High Court and District Court are competent to try all suits irrespective of their value. In such cases, there is no application of this section, but a court whose pecuniary jurisdiction has been fixed by the statute means by the law, cannot go beyond such limits. Therefore, for the application of this section, the first condition is that there must be the pecuniary limit prescribed for a court. Okay. And number B, the court whose pecuniary jurisdiction has been declared by the statute must have entertained a suit which is valued in excess of its pecuniary jurisdiction. It is very important to note here that there is no bar on filing of a suit before a court lacking pecuniary jurisdiction. It is the court who has to see whether the suit filed by the plaintiff is within its pecuniary jurisdiction. But when the court proceeds to try such a suit, then this section number 6 comes into play and restrain the court from entertaining such a suit, the value of which exceeds the pecuniary ceiling of the court. If the court passes a decree in which the court had no jurisdiction under section number 6 of the CPC, then what will be the effect of that decree? Then such a decree is null and void for the want of jurisdiction, and it will not be executable. What is the meaning of subject matter? Subject matter means the relief claimed and not property involved. I repeat, subject matter means what is the relief claimed by the plaintiff and not the property involved in the suit that has to be considered while seeking the provision of section number 6. And it is the value of the relief claimed that determines the pecuniary jurisdiction of the court. The mode of valuing certain suits for the purpose of determining jurisdiction has been prescribed in the Suits Valuation Act 1887. So, section number 6 must be read subject to the provisions of Suits Valuation Act 1887. Suits so valued exceeding the jurisdiction of the court are liable to be returned for prosecution before the proper court who has the pecuniary jurisdiction over that particular matter. What will happen if the court passes the decree in excess of its pecuniary jurisdiction? Nothing will happen. That decree will be fully executable because section 6 of CPC prescribes the pecuniary limit within which the court should try the suit. There is a restriction on the trial of the suit. There is no restriction on the decree. If the suit filed by the plaintiff was within the pecuniary jurisdiction, then the court is not bound to pass the decree within the pecuniary limit. The court may pass a decree for the sum which is in the excess of the pecuniary jurisdiction of the court. Similarly, if different suits which are severally or differently was within the jurisdiction of the court are consolidated, they are clubbed together, then the court does not lose its jurisdiction by the reason of the value of all the suits taken together exceeds its jurisdiction. For example, if 3 suits were filed before a court who has the pecuniary jurisdiction up to rupees 10 lakh, and that suits was first suit was filed for a sum of rupees 4 lakh, second suit was filed for a sum of rupees 6 lakh, and third suit was filed for a sum of rupees 8 lakh. All the suits of 4 lakh, 6 lakh and 8 lakh was severally within the jurisdiction of the court. But if for the convenience of the parties, they are consolidated together into a one suit. Now what is the amount? 8 plus 6, 14, 14 plus 4, 18 lakh. Now the consolidated amount is equal to 18 lakh. But the pecuniary jurisdiction of the court is up to rupees 10 lakh. Now the question arises whether the court had the jurisdiction over this consolidated suit. Then the answer is yes, because severally all the suits are within the jurisdiction of the court, but now they are consolidated. For this reason, the court does not lose its jurisdiction only by the reason that value of all the suits taken together exceeds its pecuniary jurisdiction. Okay. Further, the competence of the court to which the decree has been transferred for execution will have to be determined with reference to the valuation of the suit. Valuation of the suit which was valued at the time of filing of the suit in which the decree was passed, and not with the reference to the amount for which the decree sought to be executed has been passed. So, for the purpose of checking the competence of executing court, a reference is to be seen to the value of the suit which was made at the time of filing of the suit, and not the amount of decree for which the suit was decreed. What is the meaning of mesne profit after the suit effect on pecuniary jurisdiction? It is very important that whenever we are suing to the defendant for mesne profits along with the possession of immovable property, then the value of a suit for the recovery of possession and mesne profit is the value of the immovable property, plus mesne profits up to the date of filing of the suit. Okay, two things is to be taken into consideration. for valuing of a suit for the recovery of possession. First of all, what was the value of the immovable property? And Mesne profits up to the date of filing of the suit. Mesne profit after the date of filing of the suit do not form part of the cause of action, even though there be such a prayer in the plaint for Mesne profits after the date of filing of the suit. And the court has got the jurisdiction to fix the Mesne profit from and after the date of institution of the suit and to pass a decree thereof, although the amount may be beyond its pecuniary jurisdiction, because the decree can be passed beyond the pecuniary jurisdiction of the court. What will happen if there is subsequent increase of pecuniary jurisdiction of the court? If initially the court had not the pecuniary jurisdiction to entertain a suit, but during the pendency of the trial, the pecuniary jurisdiction has been increased by the law, then no objection as to the jurisdiction can be raised if the court passed a decree for property the value of which exceeds its initial pecuniary jurisdiction. Now let us discuss again in case where the pecuniary jurisdiction is increased during the pendency of the trial, then no objection as to jurisdiction can be raised if the court passed a decree for property the value of which exceeds its initial pecuniary jurisdiction. So this is something about section number 6. In the next lecture, we will discuss how to give application under section 6 of CPC. Thank you very much.